Hello everyone, and welcome to another edition of our discussion series on board meetings. Today we're talking about and discussing what it means to have a board hearing that's fair and impartial. I'm Executive Director Wade Pogany, and to my left is Gerry Kaufman, who is the Director of Policy and Legal Services. And to my right is Dr. Randy Royer, who is in charge of Director for Board Development. Thank you, gentlemen, for joining me today and having this discussion. We're talking about the board's role when they're serving in a hearing and how important that role is for a board and what they can do. And they really serve kind of as a judge and a jury when they're in a hearing environment. So my first question is, what are the most common types of hearings that a board would be involved in?
Probably the most common type is a student issue, usually a suspension or expulsion of the student on some violation of district policy.
Go ahead.
Is the most common. The second most common, and not as common as student issues, is an employee issue, usually like a teacher termination hearing.
So generally with student involvement in some kind of a discipline maybe, or a teacher hearing of some kind.
I'd expand just on the teacher hearing, and teacher hearings can take a lot of different forms or reasons in terms of it. A lot of them are contract related, contract non-renewal, contract termination. It can be an employee grievance by an individual employee or a group of employees. And then most, if not all, school districts also have policies related to what I call public complaints against school employees, which are more than teachers, but if somebody from the public has a complaint, that can work its way through the system and end up in a hearing before the board as well.
And sometimes those hearings, once they've happened, we know of situations where they've gone on now to a circuit court or a Supreme Court. So tell me a little bit about when it gets to the court level, if it should ever get there, what are some things that courts are looking at about the hearing itself?
Well, the South Dakota Supreme Court has said, first of all, that school boards are creatures of the legislature, and so the role of the court is not to substitute its judgment for a school board, but a court will basically look really at three things. One, does the board have the authority to conduct the hearing and make a decision? Two, did the school board follow the procedure all the way through the process? And then the third thing that probably relates most to the topic of fair and impartial is whether or not the board decision is arbitrary, capricious, or an abuse of discretion. Was it fair?
So they generally don't look at the decision that was made. They're really looking at the process that was followed. So it is critical then for boards to understand that process and know what they can and can't do. Would you say that's true?
Very definitely,
Okay.
Yes.
We hear the term fair and impartial when that comes up, especially with hearings. What does that term mean, and what should school board members do to make sure that they remain fair and impartial? What does that mean?
Well, basically, for me, it would be that they don't hear about the situation before it comes to the board level. Say in a teacher termination hearing, at some point the superintendent will recommend to the board to terminate this teacher. And rather than getting into all the details at that time, probably a board member should just ask, well, do you have all the documentation so this will withstand a hearing? If he says yes or she says yes, then you're good to go and you follow the recommendation of the superintendent. Because when it comes back to the hearing level, if it does, you will get all those details. And that's when the board then should hear all those details and then make their decision based upon those facts presented at that time.
Okay.
And if I could may add that fair and impartial a lot of times will indicate the question asked by a court is whether or not the board as an entity or individual board members maybe went into the hearing with a preconceived idea or opinion or a decision made before the hearing and being presented with the facts that Randy is talking about. By way of example, there was a South Dakota Supreme Court case really, approximately 20 years ago, and it dealt with a coach's non-renewal of the contract, not the teaching aspect, where the board president had asked the coach, an early basketball coach in mid-November, to resign. Coach didn't. 2 days later, there's a special board hearing. And even prior to the board hearing, the board president and another school board member had went and talked to somebody to see if he would come in and be the basketball coach. And the coach was suspended with pay upon advice of counsel, got reinstated, coached the season, but then the athletic director principal recommended renewal of the contract with reservations in February. In March, changed the recommendation to non-renewal. The board non-renewed the coaching contract, it goes into court, and the Supreme Court, in its decision, references all this prior involvement where board members are at board meetings asking the coach about how you select all-conference team, most valuable player. Evidence came out where one board member had called the coach after a game, asking why his son got taken out of the game. Another school board member questioned why his son didn't make the varsity. And the Supreme Court said 4 out of the 5 governing board members had personal issues at stake. They wanted the coach out. And so the hearing that ultimately was held, there wasn't substantial competent evidence to say the coach should have lost his coaching job. It's knowing too much too soon and not being fair in the process.
And to summarize slightly, they got involved before it really got to the board level. The board members got involved in the whole process, the personnel issue, before it really got to the board level.
So it really becomes serious then at that point if you've had prior involvement, because you have to serve as judge and jury then, you're already prejudiced.
You can't be fair and
You
impartial.
can't be fair and impartial. And then the courts will rule in that case.
Right, because, and again, probably the majority of school board cases that go into court, if a board's going to get reversed, it's reversed either on the procedure or on the fair and impartial bias concept that we're talking about as compared to the merits of the case itself.
So what advice would you give school board members then if they hear about a student issue or they hear about a teacher issue, which they quite often do from the community? What would you tell them in terms of their involvement in that? What advice would you give them?
Don't. Just don't get involved. I mean, that's not your place as a board member. Your place as a board member is when it comes to the board level at a hearing, then you make a decision. If you get involved too soon, then you may have that ruling against you.
So I might need to give that information to my superintendent to look into and investigate, but I, as a board member, should stay away from that then.
Recite the chain of command.
Yeah.
Yeah, and refer the person, whether it's an employee or a patron, a parent, whoever, to the administration, remind the person, and be willing to provide them with a copy of the appropriate policy. If it's a parental complaint policy, by way of example, provide them with the information as to the procedure and the avenue, but don't get involved in terms of being a decision maker, being investigator, or any of those kinds of things, because if it gets to the board, the rule is you have to be fair and impartial.
Yeah, that's the rule of thumb that we have to act. So if I'm too involved in it, at that point, if the hearing does happen, I can't be fair and impartial then.
You've muddied the waters.
Yeah.
You can't.
So we need to stay in our lane and make sure that we have other people take care of those things.
Yeah.
Good.
If I may, real briefly, I would add one more thing. If it got appealed into circuit court, okay, because these hearings are going to take place in executive session. If an issue gets appealed into circuit court, and if there is an issue about whether or not there is board bias or fair and impartial, okay, in a lot of those court appeals, there are like trials, like hearings, and board members can be called as witnesses to recite the facts, prior knowledge, etc. Because the court will look so closely at an individual's right to have a fair and impartial decision made.
So even though as board members we deal with a lot of policy, which is kind of a legislative role, we can also get involved in a judicial role with hearings. And so we have to act as judge and jury then and have to remain very unattached and as we call it, fair and impartial.
Yes.
And make a decision based upon the facts as they're presented.
Right, right. Thanks, gentlemen. I appreciate your time and thank you for listening.